If you're a small business in Alberta and you're looking to let go of one of your employees, you may be wondering what you owe them on termination of their employment. While many different things affect this situation, one of the primary considerations are the terms of the employee's employment contract, particularly the termination clause. I'm Mike from Cash and Legal, and in this video, I'm going to discuss the importance of having an enforceable termination clause in your employment contract. At the end of this video, you'll have a better understanding of employees' rights to notice or pay in lieu of notice, the importance of having an enforceable termination clause, and some of the common mistakes that employers make when drafting their employment contracts. Let's start with the context, specifically the basis for an employee's right to notice or pay in lieu of notice. In Alberta, there are two basic sources of the right to notice or pay in lieu of notice: the Employment Standards Code and the Common Law. The Employment Standards Code is a piece of legislation that establishes a variety of different basic rights for employees throughout Alberta. One of these minimum standards is the right to notice or pay in lieu of notice, which is applicable to almost all employees throughout the province of Alberta. These minimum standards are set out very clearly in the Employment Standards Code and are determined solely with reference to the employee's length of service with their employer. However, it's important to stress that these minimums are just that, minimums. They are not a cap on the maximum amount owed to the employee. In fact, if an employee does not have a written employment contract with their employer, or their contract doesn't have an enforceable termination clause, the employee is entitled to common law notice. Common law notice, also called reasonable notice, is not a fixed calculation, but a judicial determination, assessed with reference to a variety of different factors, including the employee's age, length of service, position with the employer, and the availability of comparable employment. The distinction between these two different sources of the entitlement to notice or pay in lieu of notice is very significant. The large discrepancy between these two entitlements demonstrates the importance of having an enforceable termination clause in your employment contracts. So what does a termination clause do with an employee's entitlement to pay in lieu of notice? When properly drafted, a termination clause achieves certainty for your small business by limiting the employee's entitlement to notice or pay in lieu of notice to the mandatory minimums under the Employment Standards Code. This means that if you have an enforceable termination clause in your employment contract, you can terminate the employee's employment by only providing them with the minimum notice under the code, and you do not need to worry about the employee claiming for common law notice. In addition to creating certainty around the termination process, this allows you to reduce your litigation and legal risk. Put another way, this allows your small business to end the employment relationship with certainty about the obligations you have to the employee. Now that we've established the importance of having an enforceable termination clause, let's talk about some of the major considerations when drafting a termination clause. In order to be sure that your termination clause will be enforced by the courts, there are two main things that need to be considered. The first major consideration is that the wording of the termination clause is clear and unambiguous. If the wording of the termination clause is not clear and unambiguous, the courts will not enforce the termination clause and they will award the employee common law notice. For example, there are court cases where termination clauses said that the employee would receive pay in lieu of notice in accordance with the Employment Standards Code. The courts found that this language was not clear and unambiguous in limiting the employee's entitlement to pay in lieu of notice, and they found that this employee was actually entitled to common law notice. These types of court decisions establish the importance of having clear and unambiguous language in your employment contracts that limits your employee's entitlement to common law notice. The other major consideration is to ensure that the termination clause does not attempt to deprive the employee with any benefits they have under the Employment Standards Code. This means that you cannot have a termination clause that purports to provide the employee with less pay in lieu of notice than they would receive under the Employment Standards Code. If the courts find that the termination clause is drafted in such a way that deprives the employee with benefits they would have under the code, the courts will find that the termination clause is against public policy and void. And this analysis is not restricted to the termination clause itself, because there are other court cases where they pointed to other parts of the employment contract that invalidate the code and use those clauses to invalidate the termination clause as well. For that reason, it's important to ensure that the entire employment contract aligns with the code. What are some other important considerations for drafting enforceable termination clauses? Sometimes employers want to provide employment contracts that provide benefits that are greater than the Employment Standards Code so as to entice the employee to accept employment with the employer. For example, you may be recruiting an employee for a particularly competitive position, and that employee may be mindful of their entitlements on termination before they sign their employment contract. In that situation, it's still important to have language that clearly and unambiguously limits the employee's entitlement to pay in lieu of notice to whatever is set out in the contract itself. If that language is not clear and unambiguous, the employee might be able to claim common law notice in addition to their contractual benefits. We also stress that employers are mindful when dealing with employees who are entitled to any form of variable compensation. Sometimes variable compensation can be a little tricky to ensure that the employee is receiving everything that they are entitled to receive under the code. In these situations, we often see contracts that deprive employees with benefits that they might receive under the code, and that renders the clauses void and unenforceable. The bottom line is that without an enforceable termination clause in your employment contract, your employees can claim common law notice. Common law notice is significantly greater than the mandatory minimums set out under the code. Therefore, there is a very good reason to have enforceable termination clauses in your employment contracts. If you're looking for help in drafting your employment contracts, we can assist you with this. We provide employers with clarity about their circumstances, strategies for difficult situations, and peace of mind through sound advice and strong representation. If you're looking for support with your employment contracts, do not hesitate to click the link to our website in the description of this video and book a consultation with our office.